Unit 8, Agency Contracts, Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Describe agency contracts and practices for working with sellers, including the reasons for the necessity of listing agreements, laws that affect how licensees solicit clients and customers, conditions under which brokers earn their professional fees, different types of agency contracts, advantages of placing listings in an MLS, information required by MLS rules and North Carolina contract forms and various required features of contract forms, and reasons for the termination of a listing agreement. Discuss the role of the North Carolina Residential Property Disclosure Act as well as the mineral oil and gas disclosure in listing properties. Discuss working with buyers, including the role of the buyer agency, representation agreement, purpose and use of the working with real estate agents form when working as a seller's subagent, a buyer's agent, and sellers as a buyer's agent, and the buyer agency agreement. Review the role of licensees when working as dual agents. Calculate commissions, key terms, antitrust laws, buyer agency agreement, co-brokered sale, co-listing, comparative market analysis, cooperative listing service, employment contract, exclusive agency listing, exclusive right to sell listing, extender clause, fee-for-service agreement, frontage, in-house sale, limited services agreement, listing agreement, mineral and oil and gas rights mandatory disclosure statement, multiple listing service, national do not call registry, net listing, North Carolina Residential Property Disclosure Act, open listing, override clause, price fixing, procuring cause, protection agreement, puffing, ready, willing, enable buyer, retainer fee, success fee, learning objective. Describe agency contracts and practices for working with sellers, including the reasons for the necessity of listing agreements, laws that affect how licensees solicit clients and customers, conditions under which brokers earn their professional fees, different types of agency contracts, advantages of placing listings in an MLS, information required by MLS rules and North Carolina contract forms and various required features of contract forms, and reasons for the termination of a listing agreement. Agency contracts and practices for working with sellers. As mentioned in Unit 7, an agency agreement for brokerage services creates a special agency relationship between the principal and the agent, where the agent is authorized to represent the principal and the principal's property to third parties, including submitting or receiving offers for the property. Per NCREC Rule A-104, all written agency agreements must be signed by all parties, include the broker's real estate license number, have a definite termination date, and contain the prescribed non-discrimination provision. This unit will review in depth the different standardized agency agreements used in sales transactions and closely examine a typical listing process. Why use a listing agreement? Just as a supermarket without inventory will have no customers, the real estate industry without inventory will have no business. To acquire inventory, most brokers obtain listings of properties for sale. Under the provisions of North Carolina's real estate license laws, only a broker firm having an active license can act as an agent to list, sell, or rent another person's real estate. The first type of contract an agent is likely to encounter is the listing agreement. As with most agency agreements, the listing agreement is an employment contract rather than a real estate contract. With a listing agreement, the broker firm is hired to represent the seller principal, but real property is not transferred. An agreement for brokerage services between a broker and an owner of real property must be in writing from the outset of the relationship. Note, however, under NCREC rules, an oral agency agreement with a property owner, whether a listing contract with a seller or property management agreement with an owner, is not permitted. The agreement must be in writing before any brokerage services are provided. There is only one exception to this rule if sellers did not originally give permission for dual or designated dual agency in the listing agreement, and the buyer agency agreement has not been reduced to writing. The sellers can orally amend their written listing agreements to authorize either type of dual agency at a later date. This oral consent to dual agency must be reduced to writing prior to submission of the first offer on the property. Note, throughout this unit, unless otherwise stated, the terms broker and agent are intended to include both the non-provisional broker and a provisional broker working under the broker in charge. However, only the broker firm has the direct authority to provide services to a principal. The individual brokers will usually provide services as a subagent. Laws affecting solicitation of clients, customers. The obvious first step to securing a listing agreement is to identify possible seller clients. The exploration of various methods to locate and solicit clients is beyond the scope of this text. Despite that point, it is imperative that several important legal and ethical issues be addressed that might modify the method utilized. Soliciting active clients of other firms, brokers. Article 16 of the Realtor Code of Ethics prohibits members of the National Association of Realtors from the solicitation of business from a consumer that is party to an active exclusive agency agreement with another realtor. Regardless of one's trade affiliation, it is ill-advised to solicit a property owner subject to a current listing agreement. Not only will such unethical behavior create controversy among fellow real estate brokers, it could be the foundation for a lawsuit for tortious interference with contractual relations. Even the appearance of encouraging a party to breach their contractual duties should be avoided at all costs. In practice, should a consumer express dissatisfaction with his or her current broker or brokerage firm, a real estate professional should refrain from making any comments about that broker or firm. Rather, the professional will suggest that the consumer contact the broker in charge to express his or her concerns. Some listing firms permit their clients to cancel their listings if they are unhappy with the services they have been provided. Some firms charge a cancellation fee, however, to cover some of the expenses that may have been incurred on that client's behalf. Do not call laws, rules. In 2003, federal do not call legislation was signed into law, and real estate professionals must comply with the provisions of the National Do Not Call Registry. The registry is managed by the Federal Trade Commission. It is a list of telephone numbers from consumers who have indicated their preference to limit the telemarketing calls they receive. The registry applies to any plan, program, or campaign to sell goods or services through interstate phone calls. The registry does not limit calls by political organizations, charities, or telephone surveyors. A real estate broker may call a consumer with whom they have an established business relationship for up to 18 months after the consumer's last purchase, delivery, or payment, even if the consumer is listed on the National Do Not Call Registry. A broker also may call a consumer for up to 3 months after the consumer makes an inquiry or submits an application. Note that if a consumer asks a company not to call, even if there is an established business relationship, the company must abide by the consumer's wishes. Real estate brokers are prohibited from calling registered owners of for sale by owner properties or owners of expired listings with another firm, since these solicitation scenarios are subject to the Act. On the other hand, a buyer's agent may call for sale by owners that are on the registry if the buyer client is interested in the property. On the National Do Not Call Registry, the only information accessible from the registry is a registrant's telephone number. Telemarketers and sellers are now required to search the registry at least once every 31 days and drop registered consumer phone numbers from their call lists. North Carolina's Do Not Call statute mirrors the federal rules and piggybacks on the federal registry. Penalties on the federal level are up to $11,000 per call, and North Carolina fines range from $500 to $5,000 depending on the violation. None of these do not contact laws prohibits real estate licensees from canvassing for business or soliciting clients by using postal mail or going door to door, working with brokers licensed in other states or jurisdictions. A North Carolina broker can share a brokerage fee with a broker from another state if that broker is actively licensed in the state from which he is making the referral and does not physically enter the state to engage in brokerage activity that requires a North Carolina real estate license. Generally, such a situation would result in a referral fee being paid to the out-of-state broker for referring a buyer or seller client to the North Carolina broker. The reverse holds true in that the North Carolina broker can receive compensation for referring brokerage business to an active broker in another state, as long as the North Carolina broker physically stays out of the state of the broker that received the referral. A North Carolina broker should secure a written compensation agreement and not assume that the out-of-state broker can or will be able to pay them. To be eligible to receive a referral fee, the broker must have a current, active North Carolina license at the time of making the referral. These fees must usually be paid to the out-of-state broker's firm and not directly to the out-of-state broker. In practice, the amount of referral fees between brokerage firms is negotiable. Prior to paying a brokerage firm, the paying firm should determine if the receiving entity is properly licensed. The Association of Licensed Law Officials maintains a database of licensing agencies, as well as lists of active licensees in a number of jurisdictions around the world. Antitrust laws. The real estate industry is subject to federal and state antitrust laws. Generally, these laws prohibit monopolies in contracts, combinations, and conspiracies that unreasonably restrain trade. The most common antitrust violations are price fixing, group boycotting, and allocation of customers or markets. Price fixing is the practice of setting prices for products or services rather than letting competition in the open market establish those prices. In real estate, it occurs when brokers agree to set sales commissions, fees, or management rates, and it is illegal. Brokers must independently determine commission rates or fees only for their own firms. These decisions must be based on the broker's business judgment and revenue requirements without input from other brokers. Multiple listing organizations, association or boards of realtors, and other professional organizations may not set fees or commission splits, nor are they allowed to deny membership to brokers based on the fees the brokers charge. Either practice could lead the public to believe that the industry sanctions not only the unethical practice of withholding cooperation from certain brokers, but also the illegal practice of restricting open market competition. The broker's challenge is to avoid any impression of attempts at price fixing as well as the actual practice. Hinting in any way to prospective clients that there is a going rate of compensation implies that rates are, in fact, standardized. A broker must clarify to clients that the rate stated is only what the firm charges. Likewise, discussions of rates among brokers from different firms could be construed as a price-fixing activity, and should be avoided scrupulously. Brokerage firms charge fees for their services based on their cost of doing business, not on any established standard imposed by an outside authority. NCREC is specifically prohibited by law from making rules and regulations that regulate or dictate commissions, salaries, or fees to be charged by licensees. Commission Rule A 109 states, "The Commission shall not act as a board of arbitration and shall not compel parties to settle disputes concerning such matters as the rate of commissions, the division of commissions, pay of brokers, and similar matters. All commission arrangements between an agent and a principal must be made in a way that shows they have been negotiated between the principal and agent." Group boycotting occurs when two or more businesses conspire against other businesses or agree to withhold their patronage to reduce competition. Group boycotting is illegal under the antitrust laws. Allocating markets or customers involves an agreement between brokers to divide their markets and refrain from competing with each other for business. Allocations have been made on a geographic basis, with brokers agreeing to specific territories within which they will operate exclusively. The division might occur by markets, such as by price range. These agreements conspire to eliminate competition and are illegal. The penalties for such acts are severe. For example, under the Federal Sherman Antitrust Act, people who are found guilty of fixing prices or allocating markets may be punishable by a maximum $100,000 fine and 3 years in prison. For corporations, the penalty may be as high as $1 million. In a civil suit, a person who has suffered a loss because of the antitrust activities of a guilty party may recover triple the value of the actual damages plus attorney's fees and costs. Brokers' entitlement to a commission. A listing broker's firm's compensation is specified in the listing agreement. The most widely used type of compensation is a commission or brokerage fee, computed as a percentage of the final accepted gross sales price. A flat fee commission is another way to receive compensation. The commission payment, usually considered earned when the broker has accomplished the work for which the broker was hired, is due at the closing of the transaction. Most sales commissions are paid when all terms of the purchase contract have been fulfilled. To be entitled to collect a commission, a broker must be actively licensed, must be employed by the principal under a valid written agency agreement, or be the procuring cause of the sale, and must produce a ready, willing, and able buyer. North Carolina provisional brokers can only be paid directly by their employing brokers, not directly by a principal. Commission Rule A-109 further stipulates that a broker in a sales transaction cannot receive any compensation, incentive, bonus, or other consideration from any party or person without full and timely disclosure of the compensation to the broker's principal. Timely disclosure must be confirmed in writing prior to making or accepting any offer. Once a broker obtains an offer from a ready, willing, and able buyer that meets the seller's terms, the seller is technically liable for the listing broker's commission. A ready, willing, and able buyer is financially qualified, prepared to buy on the seller's terms, and ready to take positive steps toward consummation of the transaction by showing willingness to enter into an enforceable contract. Even if the transaction is not consummated, the broker still may be entitled to a commission when the seller has a change of mind and refuses to sell, has a spouse who refuses to sign the deed, has a title with uncorrected defects, commits fraud with respect to the transaction, is unable to deliver possession within a reasonable time, insists on terms not in the listing, or has a mutual agreement with the buyer to cancel the transaction. In other words, a listing broker generally is due a commission if a sale is not consummated because of the principal's unjustified default. Even if the buyer backs out without legal cause after the seller has accepted the offer, the broker may be entitled to a commission, but collecting it may be difficult. To be considered the procuring cause of sale, the broker must have taken action to start an unbroken chain of events that resulted in the sale. In North Carolina, a broker who causes or completes such action without a written agency contract that promises compensation is deemed a volunteer and has no legal claim to compensation. Prelisting activities in first meeting. Brokers must gather many documents and obtain information in order to completely and accurately fill out listing agreement forms. Prior to the first meeting with sellers, brokers should advise their sellers to have the following documents and information available: copy of seller's deed, copy of survey, copy of protective covenants and homeowners association information, balance due on seller's mortgage and status of mortgage. At the first meeting with the seller, a broker should provide, explain, and review the agency form and company policies, services, while taking care to caution consumer about sharing confidential information until the agency relationship is established too. Inspect prospective seller's property and prepare listing data sheet, noting all significant features and defects. Identify personal property to be transferred and fixtures not to be conveyed. Suggest needed repairs, improvements, staging, etc. Make sure listing data is accurate and complete. Inquire about construction, alteration, repair permits. Inquire about septic system capacity, permit. Determine if a potential short sale situation exists. Verify acreage of lot, parcel from seller's deed and/or survey. Verify and properly report building square footage, and discuss marketing plan and brokerage fee. Experienced brokers report that properly completing the listing agreement and related forms can easily take 6 to 8 hours, including the first meeting with the seller. Licensees should consider breaking this time into 2 listing sessions. The first, where the broker reviews the agency form, explains the company's services and policies, and discusses the seller's needs. A second meeting could involve discussing significant aspects of the property, such as its condition, features, fixtures, as well as measuring the property. Exclusive right to sell listing agreement. You can view the North Carolina Association of Realtors exclusive right to sell listing agreement form here. Source: reprinted with permission of the North Carolina Association of Realtors. A broker's compensation is negotiable in every case. For members of the profession to attempt, however subtly, to impose uniform commission rates is a clear violation of federal antitrust laws. The important point is for broker and client to agree on a rate before the agency relationship is established. If no amount or percentage rate of commission is stated in the listing contract and a legal action results, the court may determine a reasonable commission by evidence of the custom in a particular community. NCREC is prohibited by law from regulating the amount of commission charged by licensees. Naturally, to earn any compensation, the buyer's broker must have an active real estate license and have a valid written buyer agency contract. The terms of that buyer agency agreement, sometimes called a representation agreement, will control how much compensation is to be paid to the buyer's agent and which party will pay that compensation. Buyer's agents may also be compensated by the buyer paying retainer fees and/or success fees. The retainer fee is typically an amount of compensation, usually paid up front by the buyer-client when the buyer agency agreement is established. A buyer agent must enter into a written buyer agency agreement with a buyer-client before receiving a retainer fee. This fee is advanced partial compensation for services. The success fee is due and payable by the buyer, principal on the signing and acceptance of an offer to purchase property found by the buyer's agent. Typically, however, it is actually paid at closing. The buyer agency agreement normally states that the buyer's agent will first try to recover the success fee from the listing firm via the cooperative agreement, and if unsuccessful, then from the buyer. If, after entering into a written buyer agency agreement, a buyer purchases a property without the involvement of the buyer agent, the buyer agent may be able to recover compensation from the buyer client if the written buyer agency agreement indicates that the buyer will pay the buyer agent in the event that the seller or seller's agent is unable or unwilling to do so. See later discussion, Working with Buyers, for representation agreements. Exclusive buyer agency agreement. You can view the exclusive buyer agency agreement form here. Source, reprinted with permission of the North Carolina Association of Realtors. North Carolina Commercial Real Estate Broker Lien. A 2011 North Carolina law allows a real estate broker with a written agency agreement to represent a property owner in a commercial transaction to place a lien on the property to be sold or leased to protect the broker's commission. The lien must be filed in a sales transaction after the broker has fully performed but before closing. In a lease transaction, the broker has up to 90 days after tenant possession to file the lien. A lien must be satisfied within 18 months and is inferior to all mechanics liens. Splitting of fees. Competing brokerage firms routinely cooperate on the sale of listed properties. In such a transaction, referred to as a co-brokered sale, the amount of compensation paid by the listing firm to the selling firm is negotiable. However, firms that participate in an MLS routinely disclose the amount of compensation that will be paid to a successful selling firm. In an in-house sale, where the listing agent and the selling agent work for the same firm, the brokerage company determines what the split will be to each licensee based on company policies. On some occasions, brokerage firms co-list a property. In a co-listing, brokerage firms team up to sell a property in order to obtain more exposure for that listing. For example, a property may be listed close to a county border. ABC Realty wishes to find buyers in the adjoining county but does not have the same degree of access as its competitor MNO Realty does. MNO Realty is located in the adjoining county. If ABC and MNO co-venture on this listing, they will also share in the listing commission if they are successful in finding a buyer who is ready, willing, and able. Types of listing agreements. The forms of listing agreements generally used are open listing, exclusive agency listing, and exclusive right to sell listing. Open listing. In an open listing, the seller retains the right to employ any number of brokers. As agents, it is a non-exclusive type of listing. The brokers can act simultaneously, but the seller is obligated to pay a commission only to that broker who successfully procures a ready, willing, and able buyer. Additionally, if the seller personally sells the property without the aid of any of the brokers, the seller is not obligated to pay any broker a commission. The seller can compete with the agents for the commission. If the owner or any of the brokers sell the property, all other open listing agreements on that property will terminate the authority given to those brokers. A broker who was in any way a procuring cause of the transaction, however, may be entitled to a commission if the procuring cause of sale can be proved. This type of listing agreement is not favored by brokers. Moreover, NLS rules may prohibit this type of listing from being placed in this resource. Exclusive agency listing. In an exclusive agency listing, one broker is specifically authorized to act as the exclusive agent of the principal. However, the seller under this form of agreement retains the right to personally sell the property without obligation to the broker. The seller can compete with the agent to save the commission. If the seller sells through his or her own efforts, the exclusive agency of the broker is automatically terminated. The seller is obligated to pay a commission to the broker if the broker has been the procuring cause of a sale. A listing brokerage can also offer and pay a co-opus fee to another brokerage to bring a buyer, in which case both firms would be paid. This type of listing may be acceptable to MLSs. However, brokers should exercise caution when handling such listings, since prospective buyers may become confused about whether to deal with the seller, owner, or a broker. Sometimes, sellers offer different terms of sale, depending on whether the seller is dealing directly with a buyer or with a buyer procured by a broker. Exclusive right to sell listing. In an exclusive right to sell listing, one brokerage firm is appointed as sole exclusive agent of the seller and is given the exclusive right or authorization to represent the property in question. Under this form of listing contract, the seller must pay the broker a commission, regardless of who sells the property, if it is sold while the listing agreement is in effect. In other words, no matter whether the listing firm, a cooperating firm, or the seller himself finds the buyer, the seller still must pay the broker a commission. In real estate, this is the most common form of listing agreement and the most preferred form for brokers. Please note that the listing agreement contains specific language stating that the broker is entitled to the commission regardless of who actually sells the property. The term exclusive right to sell does not imply that the broker has the authority to enter into a sales contract on behalf of the property owner. A listing agreement is not an offer to sell the property, it is an employment agreement. The seller cannot be forced to sell the property even if the offer matches the terms of the listing agreement exactly. However, the seller may be required to pay the earned commission to the broker. North Carolina Protection Agreement. When a particular property is not currently listed with any real estate brokerage firm, a buyer agent may use a protection agreement to secure a commission if that particular property is purchased by the buyer agent's buyer client. Such an agreement does not create a general listing or any agency relationship between the seller and the buyer agent. The agreement does not create a general listing. In practice, the North Carolina Realtors created the Unrepresented Seller Disclosure and Fee Agreement to address required agency disclosure to property owners selling their own property and compensation by property owners to a buyer's agent. Example: a broker may use a protection agreement when she has a buyer client who is interested in a specific type of property. The broker knows this buyer would be interested in a particular house that is for sale by owner. However, the broker does not want to suggest that the buyer view the house because the broker could lose the opportunity to earn a commission. Instead, the broker might first approach the homeowner, seller, and ask whether he would agree to pay her a commission if her client decided to purchase the home. Fee for services or limited services agreement. The internet has revolutionized the real estate profession in many ways. One of the more notable impacts of the internet is that it has allowed buyers and sellers to have tremendous access to information about real estate, housing, financing, and law. The internet has caused a radical shift in that the average consumer is now much more knowledgeable about real estate matters. With knowledge and information, a consumer is more innovative and independent. The advent of the internet also has meant that the consumer is privy to information immediately. Consumers now want instant access to real estate information. Successful brokers will understand and encourage consumers' innovation. In the process, it is critical for brokers to identify what services can be provided and to underscore the value of those services. Real estate information on the internet is often inaccurate and misleading. While emphasizing the services that brokers provide, it may be important for brokers to think of themselves as consultants, helping consumers discern valuable from less valuable information derived from the internet. While consumers are more independent, real estate expertise is almost always needed. It may be more important for brokers to be more flexible and open to seeing their occupation as a bundle of services that can be unbundled. Fee-for-services agreement or limited service agreements is the arrangement where the consumer decides which services are needed and then works with and pays the broker solely for those services. It is important to remember that this type of agreement is still an agreement for real estate brokerage services. As such, it must contain the elements prescribed by Commission Rules A 104 and unbundling services means offering services in a piecemeal fashion. For example, a consultant may want to offer a seller the following services: helping the seller prepare the property for sale, performing a comparative market analysis and pricing the property, assisting with marketing the property using the MLS and any other websites, locating and screening a buyer, completing an offer to purchase agreement and helping with negotiations, assisting with closing a transaction. A consultant may offer other services to a buyer. For example, a consultant may offer a buyer the following services: consulting on renting versus owning, helping a buyer with a mortgage pre-approval, consulting on a buyer's desired location, visiting properties with a buyer and checking property information, completing an offer to purchase agreement and helping with negotiations, assisting with closing a transaction. Note the following discussion regarding minimum level of services and the problems that can occur when providing a limited service. While brokers want to encourage consumers to use all of their services for a commission rate, when it becomes apparent that a consumer wants help with one or several services only, then it would be helpful for the broker to have in mind the best compensation model. Many brokers use either an hourly rate or a flat fee for particular services. In determining a flat fee, brokers consider the amount of hours it would take to do a particular task and multiply that by an hourly rate. In order to avoid a price-fixing claim, it is important that brokers independently establish their fees and do not develop their fees based on a norm in the industry. Brokers may also want to develop their own lists of services for sellers and buyers, as well as a list of specific services to help those consumers selling their home on their own. Communicating with consumers and identifying their real estate needs are important factors. Brokers provide an array of valuable services from which consumers can pick and choose. Knowledgeable and independent consumers can seem threatening to a broker. However, the broker has the opportunity to emphasize the value and variety of real estate services offered for varying fees. Remember that it is ultimately the broker who decides whether an unbundling of services is good for the company. Example: Chris wants to buy a house without contracting with a brokerage firm for a full range of brokerage services, but needs help writing an offer. Chris asks Sally, a broker friend of hers, to write an offer to purchase. Sally enters into a written buyer agency agreement with Chris for this limited service, writes the offer to purchase, and charges Chris a set fee for her service. Minimum level of service. Problems have emerged with the growing number of brokerages offering limited service listing agreements. These agreements may stipulate that a listing broker offers no services other than that of placing a listing in the MLS. When sellers enter into this kind of agreement, the sellers are essentially representing themselves. The seller may well be aware of this. However, when questions emerge involving the transaction, the seller sometimes turns to the buyer's agent for answers. Seller questions and broker responses in this situation should be handled carefully, or they could lead to a claim of undisclosed dual agency. In response to this problem, some states have enacted legislation defining an exclusive brokerage agreement. Other states have proposed regulations that define the minimum level of services a consumer should expect from a broker and brokerage firm. North Carolina has no laws or rules on this issue. However, the NCREC has shared some insight in the current edition of the North Carolina Real Estate Manual. While there is currently no standard limited services listing contract form, a carefully worded limited services listing agreement drafted by an attorney is perfectly legal in North Carolina. Although a broker may limit by contract the services that will be provided to a client, the broker may not limit or waive duties under North Carolina license law. The major duties of a listing agent that may not be waived or limited include disclosure of any material fact to any party, avoidance of false promises, avoidance of undisclosed conflict of interest, proper accounting for trust funds, competence in performance of duties, prompt delivery of all offers and contracts, and compliance with the Residential Property Disclosure Act. Consequently, a limited service firm that contracts with the seller to only enter the property information into the local MLS will still be held liable for the accuracy of the property information. Multiple listing services. A multiple listing clause is usually included in an exclusive listing. Brokers who are members of a multiple listing service, as it is termed in some jurisdictions, agree to pool their listings. A multiple listing provision gives additional authority to the listing broker to distribute the listing to other brokers who belong to the MLS. The contractual obligations among the member brokers of a multiple listing organization vary widely. Most listing agreements include what is called an offer of compensation and cooperation. Under this provision, the commission is divided between the listing broker and the selling broker, regardless of which party the selling broker represents. Under most MLS contracts, the broker who secures a listing is not only authorized, but obligated to submit the listing to the MLS within a definite period of time so that it can be distributed to the other member brokers. The length of time during which the listing broker can offer the property exclusively without notifying the other member brokers varies by realtor board. A multiple listing provision offers advantages to both the broker and the seller. Brokers develop a sizable inventory of properties to be sold and are insured a portion of the commission if they list a property or participate in its sale. Sellers also gain under this form of listing agreement because all members of the multiple listing organization are eligible to sell their property and are made aware of its availability. Many MLS agreements now allow all members to upload all the MLS entries onto their firm websites for even more exposure to the properties. Information needed when listing properties in MLS. It is important to obtain as much information as possible concerning a parcel of real estate when taking a listing. It is wise to complete a physical inspection of the property in the presence of the seller and collect all the physical data necessary to submit to the MLS for inclusion in its property data block. It is prudent to ask the seller to provide information on current property liens such as mortgages and copies of any property documentation they possess. Of course, it is important to make sure all data is accurate. The agent should point out any defects to the seller that may need correcting before the property can be shown. The broker should also ask the seller to verify that any improvements or major repairs made to the property were adequately permitted through the appropriate municipality. Septic system capacity needs to also be confirmed by the broker to avoid misrepresentation of occupancy limits. Also, during this phase of the listing procedure, the agent should identify all items of personal property the seller may wish to leave behind and identify any fixtures the seller may wish to remove. This process ensures that all possible contingencies are anticipated and provided for, particularly when the listing will be shared with other brokers in a multiple listing agreement. As part of the MLS agreement, listing brokers generally use a separate information form, known as a profile or data sheet, for recording many of the property's features. This information generally includes the following: names, addresses, and relationship, if any, of the owners. Legal description of the property. Size of the improvements. Age of the improvements and their type of construction. Number and general dimensions of rooms. Lot size, as well as information concerning the facilities, services, and institutions available in the neighborhood where the property is located. Information on any existing loans, including name and address of each lender, type of loan, loan number, loan balance, interest rate, monthly payment and what it includes, whether the loan may be assumed by the buyer, and, if so, under what circumstances, whether the loan may be prepaid without penalty, and so forth. Possibility of seller financing. Amount of any outstanding special assessments and whether they will be paid by the seller or assumed by the buyer. Zoning classification of the property. Current property taxes. Any real property to be removed from the premises by the seller and any personal property to be included in the sale for the buyer. Any additional information that would make the property appealing and marketable. Any required disclosures concerning agency representation. Property condition, known defects in the property, and the like. North Carolina listing contract forms. A wide variety of listing contract forms is available today. Some brokers have attorneys draft contracts for their firm's use, Some use forms prepared by their MLS, some use forms produced by the North Carolina Realtors. No matter which form is used, most listing contracts require similar information because the same considerations arise in almost all real estate sales transactions. A copy of the North Carolina Realtors Exclusive Right to Sell Listing Agreement, Form 101, is contained in Exclusive Right to Sell Listing Agreement. It is an appropriate exercise for real estate students to find the relevant clauses and provisions in this form that match the following descriptions. All listing agents should make sure the listing contract form is filled in properly and approved by the firm or the broker in charge. Note that a broker firm can draft the listing form because broker firm is a party to that agreement. A listing form is an employment agreement between the broker and the seller, not a contract between the buyer and the seller. However, the broker in charge should have an attorney approve the form. The listing agreement also must comply with NCREC rules. Agency disclosure. As previously discussed in Unit 7, the real estate broker at first substantial contact with a prospective buyer or seller in all real estate sales transactions must give and review the agency disclosure form, working with real estate agents and determine agency status. The form must be completed appropriately, hopefully signed by the buyer, seller, and a copy retained by the broker for 3 years. Review of this mandatory form will facilitate understanding of the need for agency-related decisions within the listing agreement, such as cooperation with and compensation to other firms or possible authorization of dual agency. Agency disclosure must happen before a broker begins to gather information to complete a listing agreement. The prospective client must be cautioned about sharing confidential information until the agency relationship is established. In the exclusive right to sell listing agreement, the seller is asked to confirm that he is not a party to another listing agreement on the property, and that he has received the working with real estate agents form that was reviewed by the broker. The names of all parties to the contract. Anyone who has an ownership interest in the property must be identified and should sign the listing to validate it. If the property is owned under some form of co-ownership, that fact should be clearly established. If one or more of the owners is married, the spouse's consent and signature on the contract to release any marital rights is required. If the property is in the possession of a tenant, that should be disclosed, and instructions should be included on how the property is to be shown to prospective buyers. Term of listing agreement. In North Carolina, all written agency agreements must specify a definite termination date of the agency relationship. The listing form must provide for a definite period of time with an automatic termination date. If the property has not been sold by midnight of the termination date, the listing agreement is automatically terminated without notification being required of either party. If mutually acceptable, the listing can be either extended or renewed in writing. Automatic extension or renewal clauses are prohibited in all agency agreements except for property management agreements that allow the landlord to terminate with notice at the end of any contract period. Description of the property. All listing agreements should include a clear and precise description of the real estate to be sold. While the legal description does not have to be included for the listing agreement to be valid, it is always wise to do so to avoid confusion and ambiguity. Note that in addition to the real property, all items of personal property that are to be included in the sale should be adequately described. Most listing agreements include a section that lists the items of personal property that will be left with the real estate when it is sold and the items of real property the seller expects to remove at the time of sale. Each item should be explicitly identified, even though some items may become points of negotiation should a ready, willing, and able buyer be found. Examples of items to address in these provisions are major appliances, pool and spa equipment, fireplace accessories, storage sheds, stacked firewood, stored heating fuel, leased equipment, window hardware and treatments, etc. Listing price. A listing agreement always should state the price the seller wants for the listed property. The other terms of the sale also should be included. For example, whether the price is to be paid in cash or financed is an important term. If the seller's mortgage cannot be assumed or if the seller refuses to offer any type of seller financing, then the seller must be paid in cash. Most buyers must get a mortgage loan in order to pay the seller cash, so the type of loan might be important to the seller because of loan requirements for the financed property. Remember, if the broker procures a buyer who is ready, willing, and able to purchase on the terms stated in the listing agreement, the broker will be deemed to have earned the commission whether or not the seller accepts the offer. For this reason, it is critical to clarify all terms of the listing, including acceptable sales price and how it will be paid. Note that the listing price is the proposed gross sales price. The seller should understand that any outstanding obligations, such as unpaid real estate taxes, special assessments, and mortgage and trust deed debts, remain the seller's responsibility and must be paid from the proceeds of the sale unless otherwise contractually agreed to by the buyer. Brokerage fee. The listing agreement must specify the compensation to be paid to the broker. The brokerage fee must be freely negotiable between the parties. To comply with federal antitrust laws, real estate brokers cannot state or imply that the brokerage fee is set by law, an MLS, or association of realtors, nor can they state that it is the standard or customary fee. The agreement should also address the possibility of and the permission for additional compensation to the firm. As noted earlier, NCREC Rule A-109 requires written notification to the client prior to making or receiving any offer if such a fortuitous situation arises. Note that the North Carolina Association of Realtors Confirmation of Compensation form has been created to satisfy this rule requirement, and is referenced in the listing agreement. Brokerage fees can be calculated as a commission, a flat fee, or a net amount. If the listing calls for a net fee, the agreement is referred to as a net listing. A net listing provision refers to the amount of money the seller will receive if the property is sold. The seller's property is listed for this net amount, and the broker is free to offer the property for sale at any price higher than the listing price. If the property is sold, the broker receives from the seller any proceeds exceeding the stipulated net amount to be retained by the seller. Although not illegal in North Carolina, this type of listing is not recommended because of an obvious conflict of interest. The question of fraud frequently is raised because of uncertainty over the sales price set or compensation received by the broker. The term net amount is often misunderstood and disputed. This type of listing is strongly discouraged. Protection period clause. Some listing contracts contain an override or extender clause, which provides that the property owner will pay the listing broker a commission if, within a specified number of days after the listing expires, the owner sells, rents, leases, or options the property to or exchanges the property with someone the owner originally met or made contact with through the broker. This clause protects the broker who introduces two parties, and is the procuring cause of a sale, only to have the parties intentionally delay entering into a contract and complete the transaction after the listing expires. The override clause usually parallels the terms of the listing agreement. For example, a 6-month listing might carry a broker protection clause of 6 months after the listing's expiration. To enforce this clause, the listing broker must provide the seller, within a specified time, the names of potential buyers who looked at the property during the listing period. However, to protect the owner and prevent owner liability for two separate commissions, most of these clauses stipulate that they cannot be enforced if the property is listed under a new listing agreement, either with the original listing broker or with another broker. Authority to cooperate with other firms. Since the major advantages of belonging to a multiple listing service are the sharing of listed property information and the offer of shared agent compensation, it is critical that the seller client understands and authorizes how other firms will be paid if they sell the listed property. Seller is cautioned about sharing confidential information with other brokers that might have to disclose that information to the buyer. The listing agreement should also establish the listing firm's authority from the seller to cooperate with other real estate firms in the procurement of a buyer for the seller's property. The seller client must also grant permission for the listing firm to compensate other firms through the sharing or splitting of the brokerage fee. Whether or not the listing firm or the seller client will agree to cooperate with and compensate only other firms that represent the buyer, or whether they will extend seller subagency to other firms is a very important issue, since a principal may be held liable for the actions of their agent under the law of tort. There is potential for vicarious liability for the listing firm and seller client due to the actions of the cooperating firm's brokers when they are acting as a subagent of the seller. Firm's duties. The agreement should state the obligations the broker promises to fulfill. These include but are not limited to advertising, showing the property, submitting the listing information to an MLS, presenting all offers, and accounting for funds received on behalf of the seller. A broker should comply with the principles of the agency's fiduciary duties discussed in Unit 7. All brokerage services must be delivered without discriminatory practices or intentions. Brokers should always be conscious of performing brokerage activities in compliance with federal, state, and local fair housing laws, which will be covered in detail in Unit 19. Inclusion of the following prescribed non-discriminatory language is required in all agency agreements in North Carolina. The agent shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. All Realtor-approved agency contracts must also contain additional anti-discrimination language. Broker also needs permission from the seller for certain marketing activities. For example, according to the terms of the agreement, will the broker be able to place a sign on the property, advertise and market the property using the broker's best efforts, submit the listing to an MLS, show the property at reasonable times and unreasonable notice to the seller, place a lockbox on the property, advertise the property on the internet, conduct an open house. Without written consent of the seller, the broker cannot undertake any such activities. If the seller does not wish to have the property advertised via the internet, which has become a prime advertising tool, they must opt out of this service by signing an internet advertising addendum and attach it to the listing agreement. Seller's representations and duties. Since the listing agreement is a bilateral contract, it should also state the obligations the seller promises to fulfill. These include completing the residential property and owners association disclosure statement, unless the property is exempt from the act, complying with the Lead-Based Paint Hazard Reduction Act if the property was built prior to 1978, making the property available for showing, and cooperating with the firm in good faith. The seller is asked to disclose information concerning flood hazard potential, previous use of synthetic stucco, if the property is subject to an owners association, existence of a termite bond, ownership and residency questions, and status of any liens against the property. The seller also is responsible for providing good, marketable title to convey the property and promises there are no circumstances to prevent that transfer. The seller should disclose any situation that might prevent conveyance of a clear title, and, if the property is subject to participation in a short sale, seller should complete the short sale addendum as part of the listing agreement. Seller acknowledges receipt of sample copies of the NCBA, NCOR2T offer to purchase and contract. You can view the offer to purchase form here, and the professional services disclosure and election form, the latter being a form used by brokers to make suggestions for additional services for the seller, such as inspections for review purposes, handling of earnest money. The firm's policies for holding and crediting of any earnest money needs to be disclosed, as well as the disbursement of any forfeited earnest money. Traditionally, the listing firm deposits any earnest money offered with a sales contract into its trust account in accordance with NCREC rules. Any forfeited earnest money may be given in its entirety to the seller or split between the seller and the listing firm. This provision also addresses state statute regarding disposition of earnest money that is disputed between the seller and the buyer. Dual agency. Seller should acknowledge receipt and review of the working with real estate agents form and address whether or not to authorize the practice of dual agency in any form. A concise review of the treatment of information and availability of advice from the listing agent during dual agency is noted. Authorization for the practice of dual agency or use of the designated agent option requires the seller's initials. Miscellaneous provisions. Other provisions of the listing agreement address whether the seller authorizes a home inspection, an agreement for mediation in the event of a dispute between the firm and the seller. There also is a provision for customized terms or conditions to be included in the agreement. The seller can acknowledge receipt of several standardized informational brochures on various topics. At the end of the agreement, both the seller and the agent of the firm must sign and share contact information. The broker also must include the broker's individual license number and agency status for NCREC rule compliance. Due diligence by agent. Since the real estate broker is responsible for the disclosure of any material information regarding the property, it is important to get as much initial information from the seller as possible. It is important to discover what fixtures the seller plans to sever and keep as personal property, and what personal property items the seller may be willing to leave. It is sometimes necessary to ask penetrating and possibly embarrassing questions to save both principal and agent from potential legal difficulties. It has become more crucial for brokers to determine the existence of liens due to the rising number of short sales and foreclosures in recent years. That a transaction will, or is likely to, involve lienholder approval is a material fact that must be disclosed. Identifying all parties with ownership interests can be challenging if there are deaths, divorces, and/or remarriages, so preliminary title searches are becoming more popular. If applicable, the seller must be informed of the seller's duty to give the buyer a property disclosure statement under the North Carolina Residential Property Disclosure Act, which is discussed later in this unit. If the property is a residential structure built prior to 1978, the agent must also explain the requirement for lead-based paint disclosure. The agent should also gather such pertinent information as legal descriptions. The agent's duty to discover and disclose material facts, including defects in the property, begins with a thorough personal inspection of the property. Preliminary home inspections to determine the condition of the property and initiate needed repairs or improvements are becoming commonplace. It is also good business practice to use other sources to verify information provided by the seller, such as verifying land use restrictions. In the listing of industrial, commercial, and agricultural properties, pertinent information may be extensive and detailed. A broker experienced in these areas would be best qualified to gather the information in a complete and accurate manner. The agent should also collect copies of all of the seller's legal documents concerning the property, such as the deed and survey, and verify the following: the seller's interest in the property, any land use restrictions that may apply, the size of the land, and the square footage of all the buildings. Determining square footage in North Carolina. NCREC guidelines determine the following areas to be considered living area if they meet the criteria mentioned above: attic, basement, bay window, bonus room, enclosed breezeway, chimney, closets, dormer's furnace and storage room, hallways, laundry room, and office. Include the stairs if they meet the criteria and connect to living area from which it descends, not to exceed the area of the opening in the floor. According to NCREC residential square footage guidelines, if the opening for the stairway exceeds the length and width of the stairway, deduct the excess open space from the upper level area. Include as part of the lower level area the space beneath the stairway, regardless of its ceiling height. Above grade is defined as space on any level of a dwelling which has living area, and no earth adjacent to any exterior wall on that level. Below grade is space on any level which has living area, is accessible by interior stairs, and has earth adjacent to any exterior wall on that level. If earth is adjacent to any portion of a wall, the entire level is considered below grade. Space that is at or on grade is considered above grade. NCREC guidelines address interior space as well. They state when interior space that is open from the floor of one level to the ceiling of the next higher level to include in the square footage for the lower level only. However, any area occupied by interior balconies, lofts, etc. on the upper level or stairs that extend to the upper level is included in the square footage for the upper level. If interior measurements must be utilized, a broker should add 6 inches to include the exterior wall width. When measuring attached housing such as townhouses, duplexes, and condominiums, additional measuring challenges may be encountered. Per the NCREC residential square footage guidelines, a broker should add 6 inches for the common walls in townhouses or duplexes, but add nothing for exterior walls in condos, since the unit does not include the exterior walls. Any deviations, alterations, or changes should be given special mention. When measuring and calculating square footage, the amount of living area and other area in dwellings is based upon exterior measurements except for condominiums, which use interior measurements. Utilize a 100 tape measure, begin at one corner of the dwelling and proceed with measuring each exterior wall. Write down each measurement as you go and record it on your sketch. Measure living area and other area, but identify them separately on your sketch. Look for offsets and adjust for any overlap of exterior walls or overhang in upper levels. Measure all sides of the dwelling, making sure that the overall lengths of the front and rear sides are equal, as well as the ends. Then inspect the interior of the dwelling to identify spaces which cannot be included in living area. Calculate the living area by multiplying the length times the width of each rectangular space. Then add your subtotals and round off your figure for total square footage to the nearest square foot. In the following diagram, here is a calculation of living area. 50 feet x 27 feet equals 1,350 square feet. 15 feet x 30 feet equals 450 square feet. 1,350 plus 450 equals 1,800 square feet. The garage is not living area, it is other area. The NCREC residential square footage guidelines or comparable guidelines should be used when calculating square footage. Such guidelines will assist a broker if a party to the transaction challenges their reported square footage. These guidelines contain specific procedures for measuring and reporting square footage, for which a broker would be held accountable by the NCREC and should be read closely. The best practice and most reliable way for an agent to obtain accurate square footage is by personally measuring the residential dwelling and calculating square footage. As an alternative to the agent personally measuring, the NCREC guidelines state that the agent can rely on square footage reported by other persons when it is reasonable to do so, like a buyer agent relying on a listing agent. Also, agents can rely on other professionals with greater expertise. There are some sources of square footage that are considered unreliable: the property owner, property tax records, and any source. Regardless of the source of square footage, the agent is liable. Additionally, as of 2016, brokers must retain copies of sketches, calculations, photos, and other documents used or relied upon to determine square footage for at least 3 years. Pricing the property. Once a listing decision is secured and all necessary information obtained, the pricing of the real estate is of primary importance. It is the responsibility of the broker to advise and assist, but ultimately it is the seller who must determine the listing price for the property. Because the average seller does not usually have the background to make an informed decision about a fair market value, real estate brokers must be prepared to offer their knowledge, information, and expertise in this area. A broker can help the seller determine a listing price for the property by means of a comparative market analysis. Essentially, a CMA compares the prices of recently sold and/or listed properties that are similar in location, style, and amenities to the subject property. If no such comparisons can be made, or if the seller feels the property is unique in some way, a full-scale real estate appraisal, a detailed estimate of a property's value by a professional certified appraiser, may be warranted. Avoiding conflicts of interest. Occasionally, brokers face conflicts of interest when they work with consumers. Brokers should recognize that they can be in positions to derive personal benefit, more than just in compensation, from actions or decisions made in their official capacity. For example, consider a broker with an ownership interest in a listing. Perhaps the broker is selling her own home or a property co-owned with a spouse or business partners. If an unrepresented buyer becomes interested in the broker's listing, can the broker represent the buyer? The conflict of interest is obvious. How can the broker represent herself as well as the buyer's interest when the parties have conflicting desires? North Carolina provides firm guidance. A broker cannot represent the buyer of residential listing under these circumstances. However, a broker can represent the buyer of commercial listing if the broker owns less than 25% interest, and the buyer consents after full written disclosure of broker's ownership interest. Even if the broker obtains the buyer's consent, brokers should not take advantage of buyers, nor fail to disclose material facts. Termination of listings. A listing agreement may be terminated for any of the following reasons: completion or fulfillment of the purpose for which the agency was created, expiration of the terms of the agency, mutual agreement to terminate the agency, breach by one of the parties, such as abandonment by the agent or revocation by the principal, by operation of law, as in bankruptcy of the principal, destruction or condemnation of the property, death or incapacity of either party. A listing agreement is a personal service contract with the brokerage firm, and its success depends on the personal efforts of the broker who is party to the agreement. The broker cannot turn over the listing to another broker. If the broker abandons the listing by failing to work toward its fulfillment, or if he or she revokes the agreement, the property owner cannot force the broker to comply with it. The property owner can, however, sue the broker for damages. The property owner could fail to fulfill the terms of the agreement by refusing to cooperate with reasonable requests of the broker, or by refusing to proceed with a sales contract. A property owner who cancels the listing agreement could be liable for damages to the broker. Learning objective. Discuss the role of the North Carolina Residential Property Disclosure Act as well as the mineral oil and gas disclosure in listing properties. The North Carolina Residential Property Disclosure Act. Property Disclosure Statement. The North Carolina Residential Property Disclosure Act requires that the sellers of most residential properties containing 1 to 4 units give the buyer a residential property and Owners Association disclosure statement, if required. Residential Property and Owners Association disclosure statement. You can view the Residential Property and Owners Association disclosure statement here. Source: reprinted with permission of the North Carolina Real Estate Commission. There are properties that are excluded from compliance with this act. The most common exclusions that real estate brokers will encounter are new construction that has never been inhabited, foreclosure sales, and any rent-to-own scenarios. The statement must be given to the buyer no later than the time the buyer makes an offer on the property. The property disclosure statement may be included in the sales contract, in an addendum to the contract, or in a separate document. The form is a state-mandated form and must be used when required. No other form can be substituted. Additional forms may be used, however, such as a copy of a home inspection. The statement includes disclosures about items relative to the condition of the property about which the owner has actual knowledge. In addition to existing questions about property condition, the property owner is asked if the property to be conveyed is subject to any owners' associations and governing documents that impose various mandatory covenants, conditions, and restrictions upon the lot, including, but not limited to, obligations to pay regular assessments or dues and special assessments. If the property owner answers yes to the existence of owners' associations or governing documents, the owner must answer the 4 remaining questions on the disclosure statement. In practice, the addition of these questions on the disclosure statement served to address the majority of the information previously gathered on the Owners Association disclosure and addendum to the standard NCBA and CLR2T offer to purchase and contract. This addendum has been revised to be used only for properties that are exempt from the Residential Property Disclosure Act. The Residential Property Disclosure Act also allows the owner to make no representations as to the condition of the property except as otherwise provided in the purchase and sale agreement. As befits a caveat emptor state, an owner who decides to make no representation as to the condition of the property has no duty to disclose those defects, whether or not the owner knows about them. If the property owner does not deliver the disclosure statement to the buyer prior to or at the time the purchaser makes an offer, the purchaser may cancel or rescind any resulting real estate contract. North Carolina GS 47E5 addresses the buyer's right of rescission as follows. The purchaser's right to cancel shall expire if not exercised prior to the following, whichever occurs first: the end of the third calendar day following the purchaser's receipt of the disclosure statement, the end of the third calendar day following the date the contract was made, settlement or occupancy by the purchaser in the case of a sale or exchange, settlement in the case of a purchase pursuant to a lease with option to purchase. If the buyer decides to rescind the sales contract, the buyer must give the seller written notice of the withdrawal within the 3-day period. The buyer who exercises this rescission right is entitled to a full refund of any deposit monies given to the seller. Example: a completed residential property and owners association disclosure statement was not provided to the buyer prior to contract formation on the 15th. The seller provides the buyer with a completed disclosure statement on the 17th. If the buyer wishes to exercise the right to rescind the contract based solely on the seller's failure to timely provide the disclosure statement, the buyer must give written notice of rescission before midnight on the 18th. Contract formation on the 15th would be the starting point of the 3 calendar day deadline since it occurred prior to the late delivery of the statement on the 17th. The disclosure statement should be kept accurate throughout the listing period. If, after the seller delivers the disclosure statement to the buyer, the disclosure statement is rendered inaccurate in a material way, the seller must promptly deliver a corrected disclosure statement to the buyer. If the seller fails to deliver the corrected disclosure statement or fails to make any repairs necessary to make the original disclosure statement correct, the buyer may have a legal action for damages. In addition, a residential seller must disclose what she knows about the presence of lead-based paint in the property and must provide any known reports about lead-based paint hazards in the property, as required under the Residential Lead-Based Paint Hazard Reduction Act. Review of agents' responsibilities. Non-disclosure by the seller in no way relieves brokers from their statutory duty to discover and disclose all material facts to all parties in the transaction. As noted previously, the listing agent is responsible for informing the seller that it is the seller's responsibility to complete and provide the mandatory disclosure form to all prospective buyers. Although brokers are prohibited from actually completing the form, they can provide insight and advice to the seller. The broker should also assist the seller in providing a complete and up-to-date form to the buyer or their agent. It is common practice around the state for this disclosure form to be available in the listed property or as an additional page of information on the MLS listing. All brokers in the transaction, regardless of whom they represent, have an obligation to ensure the delivery of the mandated form to the buyer in a timely manner. Mineral and oil and gas rights mandatory disclosure statement. Generally, in North Carolina, when title to a property is conveyed, the new owner is not just granted ownership of the property's surface, but also air and subsurface rights. Subsurface rights may include rights to the minerals, oil, and gas that lay beneath the surface. It is possible, however, to sever mineral, oil, and gas rights from real property. To sever the rights, property owners may either convey the rights to another by deed, or an owners may reserve ownership of the rights when conveying the property to another. If the mineral or oil and gas rights are severed from the property, the owners of those rights may have the permanent right to drill, mine, explore, and remove the subsurface minerals or oil and gas from the property. North Carolina requires owners to disclose to prospective buyers, even before an offer is made, whether or not the mineral or oil and gas rights have been severed from the property. The mineral and oil and gas rights mandatory disclosure statement requires the current property owner to disclose whether the mineral or oil and gas rights were severed from the property by the previous owner, by the current owner, and whether the current owner intends to sever the rights from the property prior to transfer of title to the buyer. If the owner does not provide the disclosure to the prospective buyer before the offer is made, the buyer may, under certain conditions, be able to cancel the contract without penalty by personally delivering or mailing written notice to cancel to the owner or owner's agent within 3 calendar days of receiving the disclosure, or 3 calendar days following the date the contract was executed, whichever occurs first. It is important to note that a disclosure statement is not required for some transactions, but is required for the sale of improved property, including transfers involving new construction, leases with the option to purchase where the lessee occupies the property, and transfers where both parties agree a residential property and owners association disclosure statement is not to be provided. Mineral and oil and gas rights mandatory disclosure statement. Click here to download the Mineral and Oil and Gas Rights Mandatory Disclosure Statement form. Source: reprinted with permission of the North Carolina Real Estate Commission. The new law applies to any sales contracts and covered transactions entered into, on, or after January 1, 2015. The following transactions are subject to the Mineral and Oil and Gas Rights Mandatory Disclosure Statement. Sales subject to the Residential Property Disclosure Act. The first sale of a dwelling never inhabited. A lease with option to purchase where the lessee occupies the dwelling. Sale of residential property where the parties agree not to complete a residential property. An owner association disclosure statement. The last 3 transactions listed are exempt from providing the RPO-ADS, but sellers of such property nonetheless must provide the MODS disclosure to prospective buyers. The MODS form lists the transactions to which it applies in the first 2 paragraphs. Owners of residential property falling within any of the 4 categories must provide the MODS to the buyer no later than the time the buyer makes an offer. The disclosure statement must be signed by the seller, and the buyer should also sign the form merely to acknowledge its receipt. The owner is required to separately disclose as to 1 mineral rights and 2 oil and gas rights whether any previous owner has severed the mineral or oil and gas rights. The current owner has severed either mineral or oil and gas rights, or the current owner intends to sever either mineral or oil and gas rights prior to transferring the property to the purchaser. Unlike the RPO-ADS where the owner may check no representation for each question, the only question on the MODS that permits a no representation response asks whether a previous owner has severed either mineral or oil and gas rights. As to whether the current owner has severed or plans to sever the rights, the owner must answer either yes or no. Ironically, this MODS does not apply to sales of vacant land, in part because the General Assembly chose to insert the disclosure requirement into the Residential Property Disclosure Act. That act only applies to sales of residential property containing 1 to 4 dwelling units. Failure to provide either the RPO-ADS or MODS when required allows the buyer to cancel the contract by hand delivering or mailing written notice of cancellation to the seller or seller's agent within 3 calendar days of contract formation or 3 calendar days following receipt of the disclosure, whichever deadline first occurs. A buyer will not be penalized for canceling the contract in a timely fashion and will be entitled to a refund of any deposit the purchaser may have paid. A broker acting as an agent must inform owners of their legal obligation to provide the mineral and oil and gas rights mandatory disclosure statement and the possible consequences of not providing the statement. So long as the broker advises the owner of their statutory obligation to provide the disclosure, then the broker will not be responsible for the owner's refusal to provide any disclosure required under the Act. All sellers of residential properties must provide buyers the residential property and owners association disclosure statement. False. Sellers of brand new homes must provide a complete mineral, oil, and gas disclosure statement to consumers. True. Learning objective. Discuss working with buyers, including the role of the buyer agency. Representation agreement. Purpose and use of the working with real estate agents form when working as a seller's subagent, a buyer's agent, and sellers as a buyer's agent, and the buyer agency agreement. Working with buyers. Like a listing agreement, a buyer agency agreement or buyer representation agreement is an employment contract. In this case, the broker is employed as the buyer's agent. The buyer, rather than the seller, is the principal. The purpose of the agreement is to find a suitable property. An agency agreement gives the buyer a degree of representation possible only in a fiduciary relationship. A buyer's broker must protect the buyer's interests at all points in the transaction. A number of issues must be discussed by a broker and a buyer before signing a buyer agency agreement. For instance, the broker should make the same disclosures to the buyer that the broker would make to a seller in a listing agreement. The licensee should explain the forms of agency available and the parties' rights and responsibilities under each type. The specific services provided to a buyer client should be clearly explained. Compensation issues need to be addressed as well. Buyer's agents may be compensated in the form of a flat fee for services, an hourly rate, or a percentage of the purchase price. The agent may require a retainer fee at the time the agreement is signed to cover initial expenses. The retainer may be applied as a credit toward any fees due at the closing. A buyer's agent may be compensated by sharing the commission paid by the seller. As in any agency agreement, the source of compensation does not determine the relationship. A buyer's agent may be compensated by either the buyer or the seller. Issues of compensation are always negotiable. All buyer scenarios in North Carolina must start with a thorough explanation of agency relationship options no later than first substantial contact. Prospective buyers must receive a copy of the NCREC's Working with Real Estate Agents form and a review of agency options available with the broker's firm. A decision must be made as to what agency relationship will exist between the buyer-consumer and the broker before the agent can provide any brokerage services to the buyer. Let us explore the different ways a broker can legally work with a buyer-consumer. Working as a seller's subagent. If the buyer-consumer chooses not to be represented by any type of buyer agency, after proper review by the broker of all agency choices in the Working with Real Estate Agents form, the broker should indicate unrepresented buyer on the form. Assuming the seller will allow seller subagency in this situation, the broker is in a fiduciary relationship with the seller, not the buyer. Therefore, the buyer should be very careful what information is shared with the broker, who must communicate everything to the seller client. The buyer-consumer should fully grasp the fact that while a broker acting as a seller's subagent must deal fairly and honestly with the buyer, this interaction falls far short of a buyer's agent's fiduciary relationship that must promote the buyer's best interest. If the buyer will not authorize buyer agency or seller subagency, the broker cannot continue to work with the buyer. There is no legal alternative. In today's real estate practice, a listing firm and seller may refuse to offer seller subagency to other firms and only co-broker transactions with firms acting as a buyer's agent. The listings of such firms cannot be shown by a broker acting as a seller's subagent. The buyer-consumer would have to enter into a buyer agency agreement with the broker, at least for that property, switching from a seller's subagent to a buyer's agent. Sometimes a buyer-consumer may decide after working for a while with a broker as a seller's subagent that the buyer-consumer would like to switch to a buyer's agency relationship with the broker. Any confidential information about the seller-client learned by the agent while acting as a seller's subagent must be disclosed to the seller when asking for permission to change the agency relationship. Although this shift in agency allegiances can be done with the fully informed consent of the seller, it is strongly discouraged. Working as a buyer's agent. Under an exclusive buyer agency agreement, the buyer has exclusive representation from one particular agent. You can view the exclusive buyer agency agreement form here. Non-exclusive buyer agency agreement. Under this type of buyer agency contract, the buyer does not have exclusive representation from one particular agent. The potential buyer is free to enter into other buyer agency contracts with other brokers, firms. This also frees the buyer to view and purchase property through a seller's subagent or to purchase property directly from a property owner. Buyer will only be obligated to compensate the broker if the buyer's broker is the procuring cause of the purchase. Buyer-agent compensation under this type of contract may involve a retainer fee or success fee, as previously discussed. Non-exclusive buyer-agency agreement. You can view the non-exclusive buyer-agency agreement form here. Source: reprinted with permission of the North Carolina Association of Realtors. Oral Buyer Agency. NCREC Rule A-104 permits licensees to work initially as a buyer or tenant agent under an express oral buyer agency agreement. After proper review of agency options in the working with real estate agents form, a buyer, tenant, consumer may wish representation but elect to postpone the execution of a written agency agreement. Minimally, the oral agreement should address issues of compensation and whether the client authorizes dual agency, if the situation arises. All oral buyer-tenant agency agreements must be non-exclusive, which means the client may work with other agents or independently, and the relationship may be terminated by the agent or the client with notice at any time. Any oral agency agreement must, by NCREC rule, be open-ended with no definite termination date. If the agent seeks to restrict the buyer-tenant's ability to work with other agents or to bind the client for a specified period, then the agreement must be in writing from the outset of the restricted relationship. Despite the legality of limited oral buyer-tenant agency use, written agency agreements are strongly preferred and should be secured as soon as possible. At the latest, an oral buyer-tenant agency agreement must be reduced to writing not later than the time any party to the transaction makes an offer to buy, sell, rent, lease, or exchange property to another. Virtually any written agency agreement will satisfy the rules requirement for written agency, whether the agreement is non-exclusive or limited to one particular property. An agent shall not continue to act as a buyer or tenant agent if the client refuses to enter into a written agency agreement when required by the rule. If the client refuses to reduce the oral agency to writing, the only way the agent can go forward in the transaction is if the client will allow the agent to switch to acting as a seller's subagent. This change must be agreeable to the seller as well as the buyer. Such a shift in agency affiliation is strongly discouraged by the NCREC because the oral buyer agent is quite likely to have gathered confidential information about the buyer client while showing property. If the client will neither reduce agency to a written agreement nor authorize the agency switch to seller's subagent, a broker is forbidden to present any offers on behalf of the unrepresented buyer, tenant, despite Rule 58A.0106 that mandates timely presentation of all offers. Brokers cannot be forced to comply with a rule that will cause them to violate another rule or law. Brokers are strongly advised to refrain from developing any offer until agency has been reduced to writing. All terms of the oral buyer-tenant agency agreement must be clearly understood by the broker and the client despite its verbal nature. The NCREC strongly recommends that the broker send the client a letter that confirms the terms of the verbal agreement, including dual agency authorization if approved. Termination of oral agency may be tendered verbally, although follow-up written communication is recommended. Firms do not have to allow oral buyer-tenant agency. It is only an agency option. Exclusive buyer-agency agreement. Under this type of buyer-agency contract, one broker firm is selected by a potential buyer to represent him or her in the purchase of a property on an exclusive basis. The buyer agrees not to work with any other broker firm in the purchase of a property. The employed broker is the only real estate firm with whom the buyer can work to locate and purchase property. When the buyer has signed an exclusive buyer-agency contract, all agents working for that firm become subagents of that buyer. The buyer, however, may not be restricted from buying directly from a property owner, but language in the contract can still require the buyer to pay the broker a success fee. Some buyers who are resistant to an exclusive agency agreement may be more willing to sign if the agreement is short in time duration or limited to named properties. An exclusive buyer-agency agreement must be in writing from the formation of the exclusive agency. A buyer-agency agreement terminates automatically on the date stated in the agreement, unless renewed by that expiration date. It also terminates upon the closing of a purchase obtained by the buyer's agent. The exclusive buyer-agency agreement is an example of an exclusive buyer-agency agreement. Buyer agent's responsibilities. A buyer's agent must consider the buyer's desires and financial qualifications when selecting properties for showing while making sure not to violate fair housing laws. Buyer's agents should not limit selections to properties listed by the agent's firm or exclude those properties listed by a limited broker, or those listings where the commission split may be perceived as low. It is the buyer's needs, not the broker's, that should be most important in the selection of properties to be shown. When scheduling properties for showing, the buyer's agent must disclose his or her agency status to the listing agent at initial contact. Any expected compensation by the seller or the listing firm should also be clarified by the time of the showing by obtaining a cooperation agreement with the listing company, if needed. A buyer's agent must also give and review the working with real estate agents form with the buyer. Explain agency duties and responsibilities. Ensure that a proper agency contract is executed. Properly qualify the prospective buyer, client. Obtain and verify information about the property, including, if applicable, the residential property and owners association disclosure statement, the mineral and oil and gas rights mandatory disclosure statement, the lead-based paint addendum, and the owner association disclosure and addendum, etc. Disclose agency status to all parties to the transaction. Show properties that meet the requirements of the buyer. Discover and disclose material facts about the property. Perform a CMA to assist buyer in determining an appropriate offer price. Assist in the preparation, presentation, and negotiation of offers submitted by and on behalf of the buyer, client, and assist the buyer, client with preparation for closing the transaction. Working with sellers as a buyer's agent. Occasionally, a buyer client is interested in a property that is not listed with a full-service real estate firm. There are two scenarios that would necessitate a buyer's agent to contact the property owner directly: a for sale by owner or a property listed with a limited service real estate firm that directs all property inquiries to the property owner. Working with an unrepresented seller. Commonly referred to in the real estate industry as a FSBO, an unrepresented seller might be willing to allow a buyer's agent to preview and or show the property to the agent's buyer client. As with most contacts with the public, the buyer's agent should provide the FSBO with a copy of the Working with Real Estate Agents form, discuss agency options, and disclose the agent's status as a buyer's agent. Brokers should be careful not to accidentally engage in undisclosed dual agency by providing service that could be construed as being on behalf of the seller. Even if buyer's agent will be compensated by the seller will not automatically be represented by the broker. Although unusual for the seller to want representation by the buyer's agent, dual agency could be created with written consent of both the seller and the buyer client. Working with seller listed with a limited service broker. Some sellers see the advantage of engaging a real estate firm to provide limited brokerage services, such as entry of the property for sale in the local MLS. Some, but not all, limited service brokers will offer no buyer's agent compensation and direct all property inquiries to the property owner. Buyer's agents should not avoid showing such listings to their clients if the property represents a possible match for their client's search parameters. Such avoidance could be viewed as a breach of fiduciary duties to buyer-client or as an antitrust boycott. Sellers, buyer's agents, and buyers would be wise to be very clear about compensation agreements before entering a transaction. The Buyer Agency Agreement. Since all agency agreements must comply with NCREC rules, there are many similarities between a seller's listing agreement and a buyer agency agreement. There are provisions dealing with similar issues such as duration of the agreement, broker's compensation, descriptions of the duties of the firm and the client, non-discrimination clause, acknowledgement of receipt of agency disclosure form, and the possible practice of dual agency. Brokers and buyers can also discuss and negotiate the possibilities of limiting representation to a defined duration as well as to specific properties. There are, of course, several unique issues with buyer agency that need to be addressed in the agency agreement. The provisions that are substantially different from the listing agreement will be reviewed using the North Carolina Realtors Exclusive Buyer Agency Agreement form. It is an appropriate exercise for real estate students to find the relevant clauses and provisions in this form that match the following descriptions. Type of property. Since the primary purpose of the buyer's agent is to help the buyer locate and purchase an acceptable property, it seems obvious that general property requirement parameters need to be established. These parameters may be very general, such as residential property within a specific county, or very specific, such as residential property that allows multiple horses within 5 miles of a major interstate road. The agreement may even be restricted to one specific property. Other professional advice. Buyer is advised to seek professional advice as needed about different matters involved in a real estate purchase from subject matter experts, such as attorneys, surveyors, engineers, etc. Although the broker may provide suggestions of available subject matter experts, the buyer agrees not to hold the broker firm responsible for the buyer's selection of advisors or the actions of the advisors. Buyer acknowledges receipt of multiple standard publications for review and educational purposes. Other inspections that should be considered include radon, lead-based paint, asbestos, mold, and well water. Confidentiality issues. Unless otherwise noted in the agency agreement, the buyer authorizes the broker to disclose the buyer's name as necessary. The buyer also is advised that although brokers are prohibited from disclosing terms of any offer without the express permission of the offering party, the seller is under no such restriction. A real estate broker may work with a buyer initially with an oral agreement, but once the buyer asks for assistance with developing an offer, the broker must be formally employed by that buyer using a written agreement. True, when scheduling properties for showing, the buyer's agent must disclose her agency status to the listing agent or to the seller if the seller is a for sale by owner. True, learning objective. Review the role of licensees when working as dual agents. Working as a dual agent. Dual agency. Dual agency involves serving as the agent for two or more parties with adverse interests in the same transaction. A real estate brokerage firm whose policy allows dual agency, electing to represent both the buyer and the seller in the same transaction, must use a written dual agency agreement no later than the making of the first offer to modify existing relationships that were created when entering into either a listing contract or a buyer agency contract. The most recent versions of the listing and buyer agency agreements have the dual agency agreement incorporated into the form. In practice, firms practicing dual agency will normally require that their brokers, when entering into either a listing agreement or a buyer's agreement, have the client authorize dual agency in the agency agreement. This meets the requirement for written informed consent and ideally should be obtained when the agency relationship is established. The dual agency provision basically gives a blanket authorization for dual agency, if needed later in the transaction. The dual agency authorization in the standard agency agreements contains provisions for agreeing to dual agency, the broker's role as a dual agent, the seller's and the buyer's roles, and provisions for the option of designated dual agency. As discussed in Unit 7, if the listing firm also represents the buyer in the purchase transaction, a dual agency situation exists that requires fair and balanced treatment of both clients. Dual agency exists whether only one or multiple firm brokers are involved because the firm is the agent of record. The dual agency provisions on all North Carolina Realtors agency agreements seek to modify and limit the duties of the agent to the principals. Both of the firm's clients are responsible for making their own decisions during the transaction. When acting as a traditional dual agent, the firm's brokers typically are absolved by the language in the dual agency agreement from sharing confidential information about either party with the other as would be required under common law agency fiduciary duties. Dual agents must still discover and disclose all material facts but not personal information, which does not affect contract performance by either client. A dual agency agreement can be drafted by an attorney to create dual agency and provide written informed consent if written agency has not been previously entered into by the respective parties to be represented by the broker. Such an agreement is required when a broker brings together a potential buyer and a potential seller in hopes of negotiating a successful transaction, but neither party has signed any agency agreement with the broker. Dual agents must still discover and disclose all material facts, but they do not disclose personal information to both the buyer and the seller. True, Dual agency agreements commonly have a provision for the parties to accept designated dual agency. True. Learning objective. Calculate commissions. Math concepts. Sharing commissions. Two brokerage firms and their brokers might share a single commission. The listing brokerage firm, the listing agent, the selling brokerage firm, and the selling agent. Drawing a diagram can help you determine which person is entitled to receive what amount of the total commission. Agent Eve, while working for a BC Realty, took a listing on a $189,000 house at a 6% commission rate. Agent Ted, while working for Holmes Realty, found the buyer for the property. The property sold for the listed price, and the listing firm and the selling firm shared the commission equally. If the selling firm kept 45% of what it received, how much did Agent Ted receive? Calculating sales prices, commissions, and nets to seller. When a property sells, the sales price equals 100% of the money being transferred. Therefore, if a broker is to receive a 6% commission, 94% will remain for the seller's other expenses and equity. To calculate a commission using a sales price of $80,000 and a commission rate of 6%, multiply the sales price by the commission rate. $80,000 times 6% equals $80,000 times 0.06 equals $4,800 commission. To calculate a sales price using a commission of $4,550 and a commission rate of 7%, divide the commission by the commission rate. $4,550 divided by 7% equals $4,550 divided by 0.07 equals $65,000 sales price. To calculate a commission rate using a commission of $3,200 and a sales price of $64,000, divide the commission by the sales price. $3,200 divided by $64,000 equals 0.05. As a decimal equals 5% commission rate. To calculate the net to the seller using a sales price of $85,000 and a commission rate of 8%, multiply the sales price by 100% minus the commission rate. $85,000 times equals $85,000 times 92% equals $78,200 net to seller. The same result could be achieved by calculating the commission and deducting it from the sales price. However, this involves unnecessary extra calculations. Sales price times commission rate equals commission. Commission divided by commission rate equals sales price. Commission divided by sales price equals commission rate. Sales price times equals net to seller. Note, the previous math problem helps the seller and the broker determine the lowest price that the seller can agree to for his property and still achieve his desired goal of paying off his expenses from the sale and netting a certain amount for his own purposes. This problem should not be confused with a concept discussed earlier called the net listing. While there are commonalities between the calculation and the concept of a net listings are often unethical and discouraged. A net listing takes place when the broker receives from the seller any proceeds exceeding the stipulated net amount to be retained by the seller. Additionally, what sellers need to net or wish to sell their property for often has no bearing on the market value of the property. Brokers must guide their sellers into understanding that market value is the most probable price the property will bring in an arm's length transaction under normal conditions on the open market. A broker performing a CMA or a broker price opinion will estimate probable sales price is likely to fall within a range. At this point, the agent should also prepare and give the seller an estimate of closing costs, which might help the seller establish the listing price. Although it is the property owner's privilege to set the asking price, a broker may reject any listing in which the price is substantially exaggerated. Once the listing price has been established, only this price can be quoted to a prospective buyer unless seller gives permission to share another price. Broker commissions are typically based on the net sales price. False. The sales price of a residential lot using a commission of $4,550 and a commission rate of 7% is $65,000. True. Key point review. A listing agreement is an employment contract between a broker and a seller that clarifies the obligations of each party. In North Carolina, the listing agreement must be in writing pursuant to rule, must be signed by all parties, must include the broker's license number, must have a definite termination date, must contain the non-discrimination clause, and may be terminated when the agreement's purpose is fulfilled, the agreement's term expires, the property is destroyed, title to the property is transferred by operation of law, a broker and the seller mutually agree to end the listing, either party dies or becomes mentally incapacitated, or either the broker or the seller breaches the contract. As an agent, the broker is authorized to represent the principal and the principal's real estate to consumers. A provisional broker is a general agent of the broker and can carry out listing services only in the name of and under the supervision of the broker in charge. Do not call legislation is found at federal and state levels. The National Do Not Call Registry lists telephone numbers of consumers who have asked to be registered and prohibits interstate calls to those numbers to sell goods or services. Many states, including North Carolina, provide their own do not call legislation for in-state calls. Do not contact legislation governs phone calls, fax, and spam email but does not prohibit brokers from contacting prospective clients by postal mail or door-to-door marketing. Broker's entitlement to commission survives if the seller has a change of mind and refuses to sell, has a spouse who refuses to sign the deed, has a title with uncorrected defects, commits fraud with respect to the transaction, is unable to deliver possession within a reasonable time, insists on terms not in the listing, or has a mutual agreement with the buyer to cancel the transaction. In an open listing, the seller retains the right to employ any number of brokers. The seller is obligated to pay a commission only to the broker who successfully produces a ready, willing, and able buyer, and the seller is not obligated to pay a commission if the seller personally sells the property without the aid of any broker. An exclusive agency listing authorizes one broker to act as the sole agent of the seller, but allows the seller to retain the right to sell the property without obligation of payment to the broker. In an exclusive right to sell listing, one broker is appointed as the seller's sole agent, and if the property is sold while the listing is in effect, the broker is entitled to a commission, no matter who sells the property. A net listing has the following characteristics. The excess over the net from the sale will go to the listing broker as commission. The broker is free to offer the property at any price greater than the net amount. Net listings are strongly discouraged as a matter of policy in North Carolina. A protection agreement guarantees compensation if a particular property is sold to a specific buyer. Broker's compensation with a principal must be agreed upon before an agency relationship is established, and can be a commission based on sales price, flat fee, or hourly rate. Fee for services agreement or limited services agreement is based on charges for separate broker activities that the client desires. Some states now require minimum services to be offered by the broker. Entitled to compensation means that an individual must be an actively licensed real estate broker, employed by a client under a valid written agency contract, and the procuring cause of the sale by starting or causing a chain of events that resulted in the sale. The commission is earned when the seller accepts an offer from ready, willing, and able buyer prepared to buy on the seller's terms and ready to take positive steps toward consummation of the transaction. Antitrust laws are both state and federal that prohibit monopolies and contracts, combinations, and conspiracies that unreasonably restrain trade, including price fixing, group boycotting, allocation of customers or markets, and tie-in agreements forcing customers to purchase a product when only another was wanted. A multiple listing clause permits cooperation with other brokers in the MLS. Due diligence by agent should discover and voluntarily disclose material facts about the property to all parties to the transaction. Square footage is not a material fact in North Carolina, but if represented, it must be correct. Heated living area is calculated using exterior measurements. North Carolina Residential Property Disclosure Act requirements include most residential sellers to provide a completed disclosure statement to prospective buyers prior to presentation of first offer. Exempted properties including new construction, bank-owned foreclosures, and lease options. Seller may choose to mark no representation. Statement must be accurate at all times. Possible 3 calendar day rescission period from contract formation or late delivery of the statement, whichever occurs first. For noncompliance, Broker not allowed to complete statement, but to facilitate delivery. And broker must discover and disclose material facts regardless of seller's representation on the statement. The mineral and oil and gas rights mandatory disclosure statement requirements include sales subject to the Residential Property Disclosure Act, the first sale of a dwelling never inhabited, a lease with option to purchase where the lessee occupies the dwelling, and sale of residential property where the parties agree not to complete a residential property. An owner association disclosure statement. Owners of residential property falling within any of the 4 categories listed previously must provide the mods to the buyer no later than the time the buyer makes an offer. The disclosure statement must be signed by the seller, and the buyer should also sign the form merely to acknowledge its receipt. The owner is required to separately disclose whether any previous owner has severed the mineral or oil and gas rights. The current owner has severed either mineral or oil and gas rights, or the current owner intends to sever either mineral or oil and gas rights prior to transferring the property to the purchaser. Owner may not answer no representation regarding the question about whether the owner has severed or intends to sever the rights. Also note that the mods does not apply to sales of vacant land. There is a possible 3 calendar day rescission period from contract formation or late delivery of the statement, whichever occurs first, for noncompliance. A broker is not allowed to complete statement, but to facilitate delivery. A broker must discover and disclose material facts regardless of seller's representation on the statement. When working with buyers as a seller's subagent, the buyer would indicate unrepresented buyer on the working with real estate agent's disclosure form, and the seller and listing firm must be willing to allow subagency. When working with buyers as a buyer's agent, the buyer agency agreement must be in writing prior to presentation of first offer. In a non-exclusive buyer agency, the agent is in competition for compensation with other agents and the buyer client. In an exclusive buyer agency, compensation is owed regardless of how property is found, and the buyer's agent is working directly with the seller in a FSBO or a limited service listing firm scenario requires agency disclosure and confirmation prior to showing property. When working with buyers as a dual agent, the agent firm represents the buyer and seller in the same transaction with permission, and all standard dual agency agreements modify the exclusive agent's duties.